Okay, the speaker is Hiroshi Fukurai. He's a professor of sociology and legal studies at the University of California at Santa Cruz. I always introduce him as one of the very few real Japanese social scientists teaching on a full-time basis at a major American university. And also, I have been very happy to be his friend for many, many years on the virtually same research topics. Okay.
Okay, thank you very much. Yes, I'm from UC Santa Cruz, and if you look at the logos, it's a banana slag that grows like 25 centimeters, and you cannot eat it like in France, but nonetheless, it's very unique. You see it quite often after rain, for example. It's kind of surprising if you see one. Anyway, thank you very much for the invitations. I really appreciate it, and I'm very feel privileged to be invited among prominent legal scholars today for this symposium. And one thing I just want to say is that I'm not a lawyer. I'm just a holder of just PhD in the United States. And the only difference between the previous presenters and I would be is that I was trained as an engineer in Japan. I changed my career, came to the United States and studied the legal system from a sociological perspective. So I tend to have a very different view on law and judicial system and legal reform. So that my presentation may reflect some of those differences that you have seen today's presentation. And I was thinking how to start my presentation, but I think I'm going to start from here. And I want you to take a look at the excerpt taken from the book written by Antonio de Nebreja. He was a bishop of Avila in Spain, and he wrote a very famous book in 1492, which is quite important. This is a book about the Spanish grammar, and he was a specialist in Castilian Spanish, that is all form of Spanish. And in the prologue of the book, he said, law and language are the perfect instrument of empire. And his book and the Spanish language has been used in the New World and eradicated, as a result, millions of indigenous languages and imposed one linguistic system. And that's one of the reasons that we see Mexico and the rest of the Central and Latin American countries speaking Spanish, with the exception of Brazil, that they speak Portugal. But nonetheless, law, according to Nebreja, represent the perfect instrument of empire. And if you actually, you can agree with it, you don't agree with it, but nonetheless, that's his prophetic vision, because he actually said that in 1492, and he knew the impact of the use of language and law for the facilitation of the colonial process, which lasted until quite recently. And if you apply that vision into different countries, and some legal scholars actually share the similar vision, and actually use the two scholars. Miyazawa Sensei actually wrote in one of the very powerful articles, which came out 2002, in reviewing the Japanese Reform Council's recommendations. He said, Japanese legal system represents the effective instrument of the government to govern citizens. It's very similar vision right there. And then the Koji Sato, he was the professor of Kyoto University. He was quite important because he became the chair of Justice System Reform Council, which we actually examining at today's presentation. He said, Japan represents the rule by law. The people are being ruled by law, and not in the nature of rule of law. And that's the kind of visions that the Professor Sato had. And that's one of the reasons Japanese judicial structures is considered as one of the very conservative and closed system among democracies. And then what is the purpose of judicial reform then? I mean, what kind of reforms you would suggest? You would breathe more power into the state, or you would actually give power to the colonized subject, that is citizens, or people who are entrapped in the statist organization called the country. what is the purpose of judicial reform? That's the question I try to answer in my presentation. I don't know whether I do a good job or not, but nonetheless, here we go. If you look at the recommendations of the judicial councils came out 2002, 2001. There are actually 5 chapters. Chapter 1 and Chapter 5 actually do not have a specific proposal. So you have only 3 chapters. And Miyazawa-san actually laid out clearly exactly the areas in which the judicial reforms need to take place, according to the recommendations of this Reform Council.
When I was more optimistic.
The first one is criminal justice, and second is civil justice, which Mark talked about. Legal education and the production of legal professionals and promotion and evaluative systems of existing legal professionals that the previous presenter also talked about, Dan, as well as Tom. And lastly, the expansion of public participation in the justice system. And I'm going to focus on 2 areas here. The first one is criminal justice. And I'm not the David Johnson, who's the student of Miyazawa Sensei, specialist in the criminal justice. But nonetheless, I try to look at the effect of judicial reform proposals upon the criminal justice through the lens of lay participation system. And before I get into my presentations, I want to introduce this very prominent Japanese lawyer, whom I'm not sure whether you are aware. And his name is Shojiro Goto. He was born in 1924, and he passed away last year. And when I was teaching at the International Christian University, ICU, and I used to live in Mure, in the city of Mitaka, and also Attorney Goto also lived very close to my house. So I used to see him quite often in the bus and trains. And I'm sure that there are many Japanese lawyers who wanted to be criminal attorneys because of his influence. So he has written a number of books, but 2 of them, one of them is here, very prominent, which he wrote with another lawyer, came out 1968, I Am at the Saiban. That's a wrongful trial. And that's where he actually pointed out the problems of the wrongful convictions. And he talked about the defects in criminal justice process as the causes of the wrongful conviction, as well as he accused of the Japanese conscious effort to suppress the reintroduction of the jury system, which Japan operated from 1928 through 1943 for 15 years. And he also became a critical member of the research group on jury trial, which was founded exactly 30 years ago, 1982. He was one of the early founders. And the Shinomiya Sensei was also a very active member of this particular group. And I joined that group in 1995. And Isan and many other prominent legal scholars also joined this particular group. Anyway, so what he actually looked at the Japanese criminal justice process, there were wrongful convictions, and he attributed to the defects in the criminal justice process, as well as lack of lay participation system. That's exactly what I'm going to talk about in my presentation. And he gave out about the 4, 5, 6 different causal factors that lead to wrongful convictions. And I'm going to present my findings, how much the recommendations and proposals by the Reform Council had dealt with the issue of the causal factors of wrongful conviction. I think we can skip here. Probably don't have time. Maybe not. Well, this is the specific areas in which the criminal justice reforms that the Reform Council talked about. And the improvement in criminal justice, they talked about 5 areas: improvement and speeding up of criminal trials, public defense for a pre- and a post-indictment stage, Prosecution Review Commission with legally binding resolution, which we think the Saiban-in trial, which is like a hybrid lay participation system between lay and professional judges, the only lay participation system that was introduced, it's wrong. Japan has another lay participation system, which actually started in 1948. But the Reform Council recommended the resolution of that particular lay participation system must be given the legal binding authority. And that made a huge difference in terms of the ways in which you look at how justice process is now being facilitated. So I'm going to talk about another system of lay participation here. It also talked about introduction of new investigative methods and trial proceedings, and lastly, rehabilitation of offenders and protection of crime victims. And with respect to lay participation, the chapter 4, I think it's chapter 4, devoted entirely upon the establishment of lay participation system, despite criminal justice reform was part of the chapter 2. So that shows you how highly regarded the lay participation was from the perspective of the Reform Council. He talked about the necessity to introduce new lay participation system, expansion of lay participation system in a civil justice system. That's one of the reasons I asked the question to Mark about the possible adoption of lay participation system in civil disputes. And the criminal justice system, it talked exclusively in terms of the Prosecution Review Commission, another lay participation system, which I just talked, which I will elaborate later on, and also talked about judge system, lay participation in the nomination of lower court judges, and as well as education about lay participation, disclosure of the information. Okay, let me briefly give you an outline of how the one most popular lay participation system operate. Here you have, as the picture shows, you have 3 professional and 6 lay judges, so total of 9 participants in this panel. And they determine outcome of trial, including sentence, sometimes death penalty. And as of March 2012, that is 6 months ago, you had more than 20,000 citizens participated. So it's quite active in terms of, from the perspective of participation of citizens. And 96% of those participants said the experience was good or very good. So from the perspective of those who participated in Saiban trial, the experience was very positive. And if you look at diversities, which probably you need to focus over here, that is 9% homemakers. That's 1 out of 10 lay participants was in fact the housewife or house husband, which is quite high compared with the statistics here in the United States. So more diversity in terms of class perspective. But unfortunately, you don't have any information with respect to race and ethnicity. Japan is not a monoracial society. It has a tremendous diversity in terms of ethnicity, nationality, national origin. You know that Okinawa used to be an independent kingdom until 1879, until Japanese government annexed it. And Hokkaido was separate, not part of Japanese modern state, but it was annexed in 1868, most of the Ainus being forced into part of the Japanese modern state. And also we have a large number of Brakumin. Brakumin Liberation Council says there will be at least 2 million Brakumin people. Those are the people who've been discriminated in Japanese society because of, through the feudal system. Up until like 10 million, some estimate large number of Brakumin who have been discriminated in Japanese society. There are many Brazilians turning to nationalizing, become Japanese. Now, this is the second lay participation system, new Prosecution Review Commission. As I said, it was created in 1948, and more than 600,000 Japanese participated in the system. But until 2009, the resolution or decision of this particular lay participatory system did not have any legally binding authority. But thanks to the people like Shinomiya-san argued, it is very important. The people's decisions should have legally binding authority. And 11 people chosen randomly from the local community participate in the deliberation. And term is 6 months. It's like American grand jury system. In the state of California, you have California grand jury system. Some people call it, it's not really a criminal grand jury system. It's like a civil grand jury system. The term is for a year. In the county of Santa Cruz, they usually get together Friday night or weekend. And they examine many civic complaints being filed against police, prosecutors, education board, prison, and so on. And those citizens actually review those complaints, and they make a report every spring. The same here. In this particular case, they actually review, not the civic complaints, but review the prosecutor's non-indictment decision. Okay, this is very important. In Japan, 99.9% of cases being indicted by prosecution result in conviction. Probably you don't have to have a court. Prosecutors' decisions translate into 99.9% of the cases, conviction. Okay? So the power of the prosecution rests on cases which are not prosecuted. Do you understand it? If you're not being indicted, then you are factually, legally innocent. And Prosecution Review Commission examines the propriety of the prosecutor's non-prosecution decision. So it zooms in to the potential abuse of power by the prosecution in Japan. And this is exactly what Prosecution Review Commission examines. This is the power of the people. And Miyazawa said, I was actually invited to speak in Korea last year because Korea had the tremendous scandal with respect to the past and present prosecutors in Busan. More than 100 prosecutors were involved in the sex scandals, bribery, and so on. And the Attorney General of Korea announced that he will investigate the possibility of introducing either American grand jury system or the Japanese Prosecution Review Commission. So as a specialist of the Japanese Prosecution Review Commission, I was invited to speak at the legal research training institute last year. But anyway, they have three decisions here. They can decide that non-decision by the prosecution was actually proper decision. In other way of saying, they could say on the basis of all the evidence that prosecutors made right decision, that they did not indict the suspect. Okay, that's the first option. The second option is this here. Non-indictment is improper. The fact that they failed to indict was not a good decision. That's the second. The third, that requires 8 out of 11 people to have this decision, that is, indictment for the given case is a proper decision. In other way of saying, if Prosecution Review Commission decided twice, okay, that the indictment is proper, then the second decision becomes legally binding. And there are a number of so-called untouchables being indicted through forceful prosecution of the Prosecution Review Commission, which I'm going to talk a little bit. Okay, now let's get back to the criminal justice system. And Shojiro Goto talked about the causes of wrongful convictions, the defects in the criminal justice system. And those are not all, but some of the major factors that actually lead to wrongful conviction. First one is use of substitute prison. That is use of police detention centers. And he said this is one of the 5 leading causes of wrongful conviction. Second is limited access to defense counsel. The suspect or defendant are limited from actually seeing the lawyer. The third is use of physical, psychological torture and violence to obtain false confession. And fourth is kind of quite unique. That is, he identified the Japanese judges' uncritical attitudes about the use of confession document. And we'll see whether use of confessionary and investigative materials are not being used in Saiban-in trials or not. And last one is limited means available for the accused to obtain a pretrial release, like a pretrial bail system, whether it's being instituted or not. And whether the Reform Council has suggested the introduction of the pre-indictment bail system, and so on. So let's start looking at the use of substitute prison. Now, if you read the recommendation of the Reform Council, substitute prison, or in Japanese, daio kangoku, only appears once. That shows you how much attention they actually pay to the heinous effects of this use of the substitute prison. As of today, there is a continued use of detention center as substitute prison, and the Reform Council's recommendation did not do much in terms of eliminating this causal factor that lead to wrongful conviction. And as a result, Amnesty International sent a letter to the chair of Mr. Honda. The Special Committee for the Criminal Justice in New Ages was actually created June last year to further continue the discussions of the reforms in the criminal justice system, because the Reform Council's proposal was not sufficient. And one of them was the elimination, potential elimination of a substitute prison. And so he was the head of this particular committee, and this committee is comprised of 25 so-called legal experts in criminal justice. But this particular discussion did not appear until 24th session, in November of last year. 25th meeting, for the first time, the Kazuko Nakayama, one of the attorneys of this committee, argued for the necessity to eliminate the substitute prison, thereby eliminating the cause, main cause of the wrongful conviction. She also argued the use of audio-visual recording device at each and every phase of the investigative process. So discussion still continues. I'm not sure how they will come out with the recommendations, but nonetheless, the discussion still continues. And the use of substitute prison still continuing. The second one, limited access to defense counsel. Now, it has tremendous impact by the recommendation and proposal by the Justice System Reform Council. And because of the recommendation, the Act to amend the criminal proceeding was promulgated in 2004. And as a result, Japan Legal Support Center was created in 2006. And soon after that, Japanese public defender system was also instituted. So it has tremendous impact in terms of giving access to the defense counsel. And just give you some statistics and how powerful this recommendation has been. 2007, detain warrants being issued, and there are 140,000 detainees, and only 6,522 obtained lawyer. And if you look at statistics over 4 years, actual number of detainee warrants actually reduced. But in terms of the legal counsel being provided to those people, mushroomed. So it has tremendous impact in terms of giving legal access to defense counsel. So this was partial success in terms of the access itself. How about this one? Use of physical and psychological torture. Violence to obtain false confession. I'll just give you some brief history about the use of torture. Torture itself was legal under Tokugawa era before the establishment of Japanese modern state, 1868. Torture as a central component of investigative methods prescribed in law. But after Japan became a sovereign state, 11 years later, Japan abolished torture as a means of soliciting confessions. And Japanese government also became a signatory state for the key international laws that prevent the use of torture. International Covenant on Civil Political Rights in 1979, International Convention Against Torture in 1999. And this is a waterboarding, and unfortunately, this method has been used in the United States in various black sites when the so-called enemy combatants or terrorists being shipped. And I'm not sure whether Japan used the waterboarding, but nonetheless, this is a picture of the waterboarding. And for the 4 decades, there are 12,000 complaints filed for the torture and abuse. And only 15 accepted by court review. So only small fragment of the complaints being actually accepted for review. Only 8 resulted in the punishment increase. So this gives like a green light to the police to do engage in torture. And I'm sure they tacitly take that as a green light and continue use of the physical, psychological torture. Now, Japanese System Reform Council used the term jihaku only twice in the entire document. So that shows you the extent to which they failed to pay attention on this particular problem. And as a result, there was no law in terms of the elimination of the use of torture or psychological pressure to coerce the defendants to make so-called forced confessions. But Tokyo prosecutor decided to voluntarily use the video recording. And in February of 2007, Tokyo prosecutor extended to 8 regional offices. And I'm sure that the National Police Agency also decided to use the audio-visual recording in a very limited number of cases. And one of the failures of the Reform Council's recommendation, as Miyazawa-san and many others said, there was no major reform, or no reform at all, basically, how police conduct itself in investigating criminal cases. And that was the David Johnson's main critique of the Reform Council's recommendation. It has no mention of the effective mechanism to stop abuse by the police in Japan. And 2010, National Public Safety Commission and National Police Agency created a study group. And as of today, no system-wide use of audio-visual recording device in the investigative process. So in this particular case, the Reform Council's recommendation didn't do a very good job of eliminating the causal factor of the wrongful conviction. Now, it doesn't mean the Japanese government was not concerned about lack of transparency. From 2007 to 2009, there were 2 legislative bills, but it was killed very tactically. Oh, 5 minutes? Okay. Oh my goodness. Okay. Maybe I can respond that in Q&A. Yeah. So, yeah, 2 bills are being killed. And, okay, maybe we can skip that one. Now, 4th one, Japanese judges' uncritical attitudes toward the use of confession and documents. And those 2 scholars actually did wonderful work in terms of the ways in which how the lack of attention, critical attention by the judges contributed to the wrongful convictions. And disregard of fairness of criminal investigative process, indifference toward the circumstance and conditions surrounding the suspect in soliciting confession, and so on. And Maruta Takashi, in his book in 2004, does a very good portrait of how Japanese judiciary or the judges actually being created and amalgamated into the system. He said, judges in Japanese courts were all children of the same type of high-income parents, all studied at the same leading high schools, went to the same bar exam prep schools, graduated from the same university, studied at the same legal training institute, without ever experiencing any other profession, spent most of their lives in court with colleagues who all share the same mode of thinking. And we also have a little autonomy, because the Supreme Court had relative control over the judges through the appointment, the reappointment, and the personal process. And there was a lack of diversity. And this one is E-Sensei's, this shows lack of diversity. He's going to talk a little bit in this particular graph, but the only thing I want you to pay attention is the 4th column here. Those are the number of people being nominated from the ranks of different areas. See, those are from Legal Training Research Institute, more than 100 being recruited every year. But look at here, nomination of assistant judges and judges from attorneys. 3 years ago, 2009, only 1 person being nominated and being accepted, and two people actually rejected. So this contributes to the lack of diversity. And uncritical attention to the investigative materials still continue. Large proportion of Saiban-in trial spends upon the reading of investigative materials in court instead of directly questioning the defendants or witnesses. This is the Supreme Court report that came out last year. 37% of trial proceedings spent in reading investigative records in court. and only 28% in questioning defendants. In the case of understanding, 2009, more than 70% of trial participants said they understood what's going on. But last year, 59% of trial participants understood what's going on, because you don't know what's going on, just because those materials actually read in court instead of actually confronting the witnesses or defendants. In the case of Kobe District Court, almost half of trial proceedings spent in reading the materials, and only 20% spent in questioning the defendants. And there are some improvement, but again, this is uncritical questions paid by the judges to the kinds of evidence that need to be introduced. Limited means available, that's the last one. And pretrial release. Because of the law in Japan, bail only being applicable in the post-indictment stage in Japan. So there is no pre-indictment bail system as of today. This is very important. And the president of the Japanese Federation of Bar Associations in 2012, 3 months ago, in the Japanese press club said, we need to have the pre-indictment bail system being established. Okay? But nonetheless, and try to eliminate the prison and lengthy detentions. But nonetheless, as of today, we don't have pre-indictment bail system. I'm going to talk about pre-trial conference procedure. We can probably talk about that. Victim participation system. There's all kinds of problems with respect to that. The problem here is when the trial is still going on, the status of the defendant as a true culprit of the crime has yet to be established, while the victim of the crime asking for capital punishment. The status of the defendant as the culprit or true perpetrator of the crime has yet to be established. So there is a collusion and of trial process. And also, they are actually part of the prosecutors. There's no independent status of the victim participant, unlike like Germany. So that's a big problem. And this is some of the lay participants complained about the victim participation system. Those are two statements. This system tends to place much greater emphasis on the feeling of crime victims and creating a tendency among lay participants to impose harsher sentences upon the defendant. In order for us to make a fair decision, much improvement must be made to this system. Other lay participants said there was discrepancy in the statements made by the defendant and the victim. We lay judges felt that there was no sufficient amount of evidence in both quality and quantity. And Yokohama Bar Association 2 years ago also said the same thing. Testimony by crime victims does not match or make any reasonable sense against the testimony made by defendants. Victim testimony does not even collaborate with those of prosecutors or the court. And legal scholars also, majority of, well, at least against the victim participation program, because they believe trial outcomes should be strictly based on the evidence and testimony, without the outbursts of victims, participants calling for the imposition of harsher sentence. 1 minute, 2 minutes?
Yeah, 2 minutes will be fine.
Now, maybe I should close my presentation by looking at the collateral impacts of two systems of lay participation in criminal process. Now, first, the Saiban-in Seido, it allowed the lay adjudication of American soldiers that are stationed in Japan. And there are two military soldiers being adjudicated in 2010, Jonathan Kim and Philip Sawyer. Very interesting, the Jonathan Kim was actually a son of the Korean immigrants. And their parents actually immigrated to the United States, have a better life. And son decided to join the military, and he was dispatched to Okinawa. And he actually attacked the taxi driver, cut up badly the back of his driver's head and so on. And he was found guilty by the panel of 3 and 6 lay judges. And he was sentenced to prison 3 to 4 years. Philip Sawyer was also an immigrant from Africa through Great Britain. He joined the American military because of the injuries that he sustained when he was in college. He needed constant medical supervision of his conditions. And he was African, and he was dispatched to Japan. He tried to rape the Okinawa woman. Both happened in the island of Okinawa. And in mostly Okinawa, as well as other places, nearly 250,000 crimes and accidents being committed by U.S. military personnel, more than 1,000 Japanese being killed, but there have been lack of disciplinary actions against military personnel. So this actually created as a deterrent against military personnel. And the Prosecution Review Commission that reviews the no indictment decisions, that led to the indictment of Deputy Police Chief of Akashi City, Hyogo Prefecture. That led to there was an accident or stampede in the pedestrian bridge, led to the killing of 11 people and injuring more than 200 people. And he was prosecuted. And for the Japanese rail derailment accident, that actually killed 107 Japanese passengers. And injuring hundreds of train passengers. And they were not indicted by the prosecution, but that went to the Prosecution Review Commission, and they decided twice. The 3 former presidents of JR West need to be prosecuted. So their trials are still going on as we speak. Ozawa Ichiro, Democratic Party of Japan, he was actually acquitted by he was not indicted by the prosecution, but the citizen filed a complaint to the Prosecution Review Commission, and they decided twice that he should be prosecuted. He was acquitted by court, but nonetheless, prosecution appealed the acquittal, so the case is still pending. And same here, American military personnel, he was drunk because he actually attended the official party at the base. He directly went back, tried to go to his apartment, and on his way, he actually caused a traffic accident, killing the 19-year-old Okinawan youth. And his accident was declared on duty because he didn't stop anywhere from the camp where he actually attended the official party and directly on his way to his apartment. And so using the Japanese-American status of forces agreement, it's called SOFA, the primary jurisdiction rested upon the U.S. military court to adjudicate the case. He was suspended for driving 5 years for killing the 19-year-old youth. Mother complained to the Prosecution Review Commission, which decided twice he should be prosecuted. And that led to the negotiation between U.S. and Japanese government last November. And they decided even in official, so-called official duty, while for the U.S. military personnel, certain cases can be adjudicated in Japanese court. So that was the change in the status of forces agreement. And that led to the trial, and then this military employee was sentenced to 3.5 years in Japanese prison. So this is the conclusion. There is actually, this is a failure. What is the effect of Justice System Reform Council on criminal justice and lay adjudication? There is a failure with respect to substitute prison. We still have that. There is no transparency very limited transparency, investigative process. There's no major reform being suggested by Reform Council on the police system and procedure. Again, that's David Johnson has been very critical of that. And there have been the public safety agencies doing intelligence work of those people who actually opposed several years ago Japanese dispatchment of self-defense force to Iraq. And the safety agencies and military intelligence agencies actually monitoring those demonstrators. So there was no mention of those activities need to be stopped. There are limited success in terms of National Public Defender System and Japan Legal Support Center, Saiban-in Seido, and ability to adjudicate military personnel. And PRC was very effective, Prosecution Review Commission. Future challenges, as I asked to Mark, lay adjudication in civil and possibly administrative litigation. Because Reform Council suggestion said there should be some possibility of lay participation in civil litigation, and which was not followed up in the later discussions. And possibly the introduction of all-citizen jury trial. Just like in Venezuela, 1999, Venezuela not only introduced the hybrid jury system, like Saiban-in. They also introduced the jury system. So Japan can actually do the same. So that's my conclusion. Thank you.
So he has covered a wide range of issues related to criminal justice. And the discussant is Keith Hand. Keith is associate professor at UC Hastings, and he teaches Chinese law and criminal procedure. And he is right now the only full-time faculty member in East Asian law. So we need his hard work to, strengthen the East Asian law program here. Okay.
Well, first, many thanks to Professor Fukurai for a fascinating and detailed presentation on the criminal justice reforms in Japan. I think given the late hour, I'm going to focus on the lay participation angle. But before I turn to that, I just wanted to say a few words about Hastings and our program here. As has been emphasized, this is the first symposium event we've held as we work to build up our East Asian law program here. And as the resident China hand, no pun intended, I'm incredibly grateful to have Professor Miyazawa here as a colleague in this broader institutional effort. As those of you who know him can attest, his energy and enthusiasm are boundless. Yes. And I sometimes wonder if he sleeps. I get emails at 2 or 3 in the morning. But I really wanted to express a heartfelt thanks to Professor Miyazawa, Associate Dean Joel Paul, and to May Cooley for organizing the event today, to our speakers for traveling long distances and honoring us with your presence and contributions, and to all their participants. It really means a lot to have all of you here and to see this support as we build up our program. And it's fitting that this inaugural symposium focuses on Japan's legal reforms. As I think Mark Levin alluded to earlier, Dan Henderson, the great Japan scholar and founder of the Asian Law Program at the University of Washington, joined the Hastings 65 Club in 1992. Incidentally, I'm a graduate of the UW School of Law. Unfortunately, I didn't have the honor of meeting Professor Henderson, but I've always felt that the tradition he brought to Hastings oriented this law school towards Asia and played some small role in the decisions and events that eventually led me here as a China specialist. As a China specialist, Professor Fukurai's research on the presentation today sparked a number of reflections, and the first relates to the ripple effects of judicial reform and development in Japan, across East Asia, and also the cross-fertilization on these reform efforts. And we started to grapple with that in some of the earlier panels and thinking about reforms in Korea and Taiwan. And we could also cite numerous examples from mainland China. Of course, when the late Qing dynasty reformers began to study and adapt Western institutions in their effort to strengthen China against foreign encroachments, they turned to Japan's Meiji-era reforms as a model. The nationalists in the early 20th century, as they began to adopt a Western-style legal system, again turned to Japan and Japan's adaptations of the continental European codes. Last night, we were talking about a more contemporary example of the state compensation law. China enacted a state compensation law in 1994. And one can trace a direct line from Japan's post-war state liability statute to subsequent statutes in Korea, Taiwan, and finally mainland China. The imprint of the Japanese statute is just unmistakable. So those are examples of borrowing, and we've also talked about examples of contemporaneous development and convergence. I suppose the reform of legal education and the introduction of graduate professional law schools would be one example. There is an analog in China in that case, and also the example of lay participation. Both of these systems have analogs in the Chinese context. China's system was originally established or is rooted in the 1954 Constitution, which contained a provision for lay judges or people's assessors. But like much of the 54 Constitution, that system was borrowed from the Soviet Union. As China embraced reform and opening after the turbulence of the Mao Zedong era, this people's assessor system was formally constituted in law, but for decades its implementation was limited and problematic in practice. It's really been over the past 12 years, a period that corresponds with the movements we've seen in Japan, that China has taken more concrete steps to implement its people's assessor system in practice. In 1999, both legislative and judicial institutions made decisions to implement the system, and over the subsequent few years, they began to enact detailed measures to do so. And then in 2003, China's public prosecutor, or procuratorate, began to experiment with a system of people's supervisors, elements of which bear a remarkable resemblance to the prosecutorial review commissions in Japan. And in 2010, at least on paper, a commitment was made to implement this system nationwide. And over the past decade, as Tom Ginsberg has pointed out, we've witnessed the creation or resurgence of these types of systems across East Asia. So I guess the first basket of questions I would pose to Professor Fukurai will revolve around these issues. To what extent are we seeing cross-fertilization in these efforts? Are scholars and officials talking to each other about these models and their experiences? We had some slightly different thoughts on that issue in the earlier panel. Tom Ginsberg suggesting that he didn't see a lot of evidence of sort of learning across these systems, but Professor Miyazawa's anecdote suggested some of these dynamics might be present, so it would be interesting to get your perspective on that. And then why are they all bubbling up at the same time? Tom Ginsberg has offered us some thoughts on that topic, this sort of top-down state building and modernization effort, which might incorporate some of the competitive elements that were referred to in one of the earlier panels. But it could be also that regional models are creating bottom-up pressures, that reformers in one system are leveraging the progress made in their neighbors to put pressure on the state to move forward with reforms. And I think Professor Miyazawa's comments suggested that dynamic might be at work. The second basket of questions relates to the problem of how we evaluate Japan's system. A range of justifications have been offered for lay adjudication, fostering citizen participation and a sense of citizenship, sort of shaking up patterns of behavior in the professional judiciary, providing a check on prosecutorial and judicial excess, creating a confidence and a sense of fairness in the judicial process, bringing the insights and experiences of citizens to these judicial decision making processes, and enhancing citizen confidence in the system. And it seems like some, if not all of these elements are at work in Japan, and at some level they all relate to an effort, it seems, to reinforce the legitimacy of the state and its legal apparatus. And we see this dynamic in China as well. The push to really implement systems of people's assessors and these new systems of people supervisors in practice was largely a response to a growing wave of criticism of judicial institutions in the 1990s. Judicial institutions being criticized as unprofessional, inefficient, corrupt. And these mechanisms are also components of a broader effort in mainland China to expand controlled channels of citizen participation in a range of contexts and to reinforce the narrative that China is building its own form of democratic participation. And in recent years, as stability challenges in China have grown, these systems have been emphasized as channels for ensuring that judicial decisions reflect the feelings of the masses, as the Supreme People's Court President Wang Shenjun has stated. As a China specialist, I have yet to see much concrete evidence that these systems are having much of an impact in practice, that they're much more than political window dressing. And there would seem to be, at least on the surface, from the perspective of a non-expert on Japan, there would seem to be more potential for lay adjudication and prosecutorial review commissions to have a substantive impact there. The political context is different. As you've shared with us, the number of lay adjudicators on a criminal panel outnumbers the number of professional judges. My understanding is that decisions that are adverse to the defendant require the votes of both the lay adjudicators and professional judges. Am I correct on that point? And your presentation suggested that many lay adjudicators seem satisfied with their experience. On the other hand, as Mark Levin mentioned, they're sworn to secrecy about the deliberations. We don't have a lot of details, it seems, about what's happened, in these deliberations. The conviction rate, as you suggested, remains at well over 99%. And I ran across an article in the Japan Times that suggested it was about the same in the 2,000 cases that had been tried under the lay adjudication system. That article was published in May 2011. And my understanding is also that prosecutors may appeal an acquittal, and that on appeal, a review of the determinations of fact can be made, but that lay adjudicators do not participate at that level. So in this context, thinking about all these factors, I wonder, has lay participation in Japan had a substantive impact on the judicial process and judicial decision making? If not, or if it's difficult to detect, given this sort of veil of secrecy, can the system truly perform a legitimizing function? Is it enough that citizens are participating? There's a perception of participation or fairness, as we discussed in the earlier panel. Or are there other metrics that we can apply in evaluating the system? And finally, if most questionable cases are weeded out at earlier stages of the criminal process, and in light of some of the concerns you raised, continued concerns about the pretrial process, should the focus of the reforms perhaps shift from lay adjudication in criminal trials to these prosecutorial review commissions? In the China context, there are also the conviction rate approaches 100%. I think it's around 98% in China. And I would argue that much more attention needs to be paid to the role of the procuratorate, the processes through which decisions are being made at earlier stages of the process, and trying to ensure fairness at that stage. And I wonder if the same thing might be true in Japan. So thank you, and I'll leave it there.
Okay, thank you very much. While members of the audience are thinking about their own questions, I'd like to ask Fukurai-san to answer his comments.
Okay. Thank you, Keith. Very comprehensive response. And I wrote down many questions, and some of them are kind of overlapping in terms of the ways in which I frame the response to your question. So I'm not really going through one by one, but nonetheless, if I missed points, you can re-question me, question again, so I can respond to that. But first one, you mentioned about the cross-fertilizations, and that was quite important. And Japanese went through the judicial reform, and it implemented the lay participation system, 2009. And Korea did that same way. And China also went through the similar reform. The last one is 2010. And I believe that's also established the qualification criteria that you really have to be a college graduate to be a lay assessor in China. So that actually limited the qualified pool to like less than 5% of Chinese population, which they didn't have before. But nonetheless, I would frame that in terms of a little more geographical things. In other words, not only judicial reform, in terms of introduction of lay participation taking place in East Asia, but it was happening almost everywhere. And after the Soviet Union collapsed in 1991, and Soviet Union was then subdivided into 15 republics, and many of those republics went through the so-called democratization process. And in the process, they introduced the system of lay participation. And Russia introduced the jury system in 1993. 2 years later, Spain also went through the same system. They introduced the all-citizen lay participation system. And as I said, Venezuela introduced that in 1999. And when Hugo Chavez took the helm of the office after he was being elected into the place of president. And soon after that, Argentina, in the province of Cordoba, also introduced the lay participation system. And Japan, and many of the other places, South Africa, for example, introduced the lay participation system, mixed tribunal system after the apartheid was actually being abolished. So if you look at the last 20 years, it was more of like a global trend of the lay participatory system is actually being introduced, not just in East Asia, but throughout the world. And I would say it's very comparable to like 200 years ago when the French Revolution took place, 1789. And they established the jury system in Europe. That spread through like a wildfire throughout Europe. And by the end of the 19th century, almost all of the modern European states introduced the lay participation system. And some countries actually abolished when the fascism came in the beginning of the 20th centuries, like Spain and Germany. They turned into a mixed tribunal that you have to have a Nazi member to serve in the mixed tribunal system. But this was like a second wave of democratization process taking place global-wide, and Japan actually was one of those countries actually being affected by it. And so that's how I frame the judicial reform, especially the introduction of lay participation system in East Asia. In terms of a sense of citizenship and also creating the legitimacy of the state, I think the success was very limited limited in some ways because there are a group of grassroots organizations, and as I mentioned, the research group of jury trial, which had the prominent defense attorneys, and as Goto is one of them, and also it had a prominent legal scholar by the name of Issa. He also participated in the jury trial in military-occupied Okinawa, 1964. He was one of those Japanese people being asked to participate in criminal trial in Okinawa, adjudicating crime allegedly committed by the 4 Japanese youth in killing the American soldier. So there, he was also one of those people who advocated the reintroduction of the jury system. They did not want, in the beginning, the mixed tribunal. They wanted the modern version of what the Japanese had introduced in 1928, all citizen jury trial. And but when the judicial reform deliberation started, and I had a wonderful opportunity to talk with the Marishima sensei, he said almost all of, without almost no exception, they were against lay participation, every one of them. But through the having the public hearings and tremendous input from the public as well as those grassroots organizations, the discourse has shifted from complete denial of lay participation into the possibility of creating the space where lay participants can actually be a part of this judicial process. And in the end, all of those people who opposed became the supporter of not all citizen jury system, but supporters of the mixed tribunal system. And because of the grassroots input and the public the voices. And so it's still a compromise. There are many citizens in Japan that the Saiban-in system, that's mixed tribunal hybrid system, is not sufficient because there is a tremendous space for the professional judges to influence the deliberative nature and content of the interactions between the lay participant and the professional judges being influencing and the opinions. Not only just through the deliberations, but they actually make decisions about the kinds of law to be applied throughout the trial. So the influence is tremendous. So I still regard the sense of citizenship is still being compromised. But nonetheless, it's a right step in the right direction. But those people who are actually still continuing to debate the introduction of jury trial regarded this as not the ultimate victory, or simply a step to the much bigger, the civil society, where you have, just like the U.S. system, the deliberation is done by lay participants only. In terms of the prosecution review commissions, you're right, and that's what Mark talked about, the secrecy requirements that impose a tremendous hardship on lay participants. But nonetheless, as I said, if you look at another lay participatory system, that's Prosecution Review Commission, that was started in 1948, more than 600,000 participants in the deliberation process. And they were imposed the same requirement. there was no litigation ever being filed by prosecution for leaking any information. So there was no danger of the Saiban-in lay participant also leaking information. But what Prosecution Review Commission did was that they actually created the Prosecution Review Commission Society. In other words, you have to be a member who participated in the deliberation, then become part of the society where you can actually talk about your experiences, but not actually getting out the information outside. And in that group had branch offices in every prefecture. Every prefecture. Yokohama has one, Tokyo has one, and even some prefecture has multiple. Prosecution Review Commission Society, solely composed of people who participated in the process. And my suggestion is, lay participants, Saiban-in participants, should create their own the group so that they can actually talk about the experiences, but not disclosing the experience outside, just like exactly what's happening in what they did in the Prosecution Review Commission Society. Unfortunately, that efforts were not being made in the creation of this particular society. There was suggestion made by the government to create this and being supported by the government. But this movement in creating the Saiban-in society has to be actually initiated by Saiban-in participants themselves, just like in the Prosecution Review Commission Society. And that will take care of those internal struggles that the lay participants may feel because of the restrictions imposed upon them for life.
So, questions from, Tom and I forgot your name, but I'm sorry, but you will be the second.
Hiroshi, I wonder if you could say a little more about the politics of this change in the Prosecutorial Review Commission. On its face, it's kind of a funny reform because the prosecutors wouldn't like empowered citizens, but neither would the defense counsel, because what the citizens are doing is urging a prosecution which guarantees conviction. So I could imagine victims' rights groups were pushing for it, maybe some general people who just like transparency, but can you tell us who exactly was pushing for this reform?
And could you also say whether they're convicted? Because I know Ozawa was not convicted, so I'm wondering whether these people who were then indicted were convicted.
Sure.
Okay.
And I will ask later Marishima-san and Shinomiya-san to give their perspectives.
Right.
Because you are directly involved in the legislation. Okay.
Yes, Shinomiya-san was involved in the deliberation of the final form of the Prosecution Review Commissions, and he's the one who suggested to have the legally binding authority being given on the resolution of Prosecution Review Commission. I actually looked into the exact questions that Tom raised, and I looked at the documents, and I found one document, only in the United States, found in the Berkeley Law Library. There was a deliberation of the discussion between Japanese Federation of Bar Association and Japanese Prosecution Review Commission, Prosecutorial Review Commission Society, which took place in 1970. Exactly same discussions. The support group to have the legally binding authority was actually a group who participated in the Prosecution Review Commission. Because their participation was very important. And they actually, that's the extent to which they actually created their own group. But they also felt being overlooked because their advisor, their decision was advisory, did not have legally binding authority. So overwhelming majorities on the basis of statistics, they argued our participation was in vain, not being followed up by the prosecution. So they made exactly same recommendation as the investigative committees that the Shinomiya-san actually participated. So that suggestion was made, strongly pushed by the Prosecution Review Commission Society. So they will make the
okay. Please give him.
Japanese Bar Association as well. Thank you.
I'm Satoru from Gokugaku University. And that was a very interesting question. But as Hiroshi told you, the bar, JFBA, has been supported or suggested to make the reform, to give the committee legal binding power. So that I think that I'm not sure. I didn't read the document, but I think that bar would said the same thing. And actually, JFBA officially published their recommendation to change that system as it is.
Your clients aren't unhappy with that position?
I'm sorry?
Your clients, criminal defendants,
Well,
should be quite unhappy.
so the point is not, the view is not point of a viewpoint of criminal justice. That was a viewpoint of from the democracy. So I think this is common with the Saiban Seido and Justice Reform Prosecution Review Committee.
I just want
People convicted?
to reflect the question raised by Frank. And you're right that the Ozawa are one of those people who are forcibly prosecuted because of the second resolution of the Prosecution Review Commission. And he was acquitted by court. And his acquittal was being appealed by the prosecution. Still, that I said, his case is still pending. And that also prevents his full political participation because of that appeals process. But I think what's really important is the people's voices have a legally binding power and over so-called untouchables. The prosecutors had something called shobun seiken, that they truly have to have, if they actually try to prosecute political heavyweights, they have to go all the way to the commanding chain, to the top of even minister, to actually ask for permission to engage in the prosecutorial process. And that's called the shobun seiken. I don't know how much time that it's being exercised. So prosecutors are not really making decision by themselves. They, as a bureaucrat, make a political decision. But people are not being bound by those inter-bureaucracy politics. So I think that's very important. And as Shinomiya-san said, it's really important exercise of democracy in Japan and construction of civil society.
マルシャさん、なんか誰がどういう効果を期待してこの制度を作ったのかっていうことですか。
検察審査会制度についてはですね、審議会の当時、市民が司法に参加する制度というものについてはいろいろなことが検討されたんです。それで、裁判員がその一つでした。で、他の分野についても同時に検討しました。その一つとして検察審査会というのが有意義な働きをしているが、これについてさらに見直す必要はないのかという議論をまず行いました。
So at the time of the discussion at the Judicial the Judicial Reform Council, they found that some the positive effect of the prosecution and investigation commissions already at that time, from the viewpoint of the certain day participations already. It was discussed together with other opportunities to seek some more the participations into the judiciaries as well as the Saiban-in judge system.
当時日弁連と検察審査会の経験者から検察審査会の決定に対してもっと拘束力を持たせるべきだという意見が審議会宛てに来ていました。日弁連とそれから検察審査会にない OB の人たち。
So at the same time timing, the opinions by the JFBA, Japan Federation Bar Association, and the alumni association of the members for the district prosecution and investigation commissions really they recommended the Judicial Reform Council to enhance the functions of the district prosecution and investigation commissions on the prosecution process.
もう一つあったのは、審議会では裁判官制度の改革と弁護士制度の改革は議論したんですが、検察官問題についてはほとんど議論がなかったんです。で、そうしたときにこの問題は検察官問題の 考える一つのきっかけだということで、議論に上りました。
In the discussion of the Judicial Reform Council, they discussed about mainly the judiciary system, judicial procedure, and the lawyers. But they didn't much discuss about the public prosecutors system. So then this kind of the review on the Prosecution Investigation Commission was considered as the kind of the good opportunity to consider also some reforms on the public prosecution.
で、検察官の不起訴処分の中には政治的な思惑の中から不起訴になっているものもあるのではないかなどという議論があって、この検察審査会の決定に今回のような拘束力を持たせるという方向の議論が生まれたわけです。検事の不起訴処分の中に政治的な判断が含まれているのではないかという議論がありました。
So there are some reasons why such the opinions supporting review came from, because they were really suspecting the somewhat possibility of the political influence on some discretionary non-prosecution judgment by the public prosecutors under the old system.
で、先ほど述べたように検察審査会の同じ決定、2回にわたる同じ決定について拘束力を持たせるという結論に至ったわけです。
So, as a result of the discussion at the Judicial Reform Council, so they recommended finally at least the decision made by the Prosecution Investigation Commission should be the binding to prosecute a certain indicted person if the commission made the same decision to prosecute twice.
で、ここで起訴された案件を誰が公判を担当するのかという問題が起きました。検察官は自ら不起訴にした事件を公判で維持することは嫌だと言ってこれは拒否しました。それで指定代理人制度が生まれました。
Of course, the final problem was who should proceed the procedure after the Prosecution Investigation Commission decided to prosecute under the binding decisions. The public prosecutor office refused to take the case again because exactly the decision made by themselves was once refused or denied by the commission. So then finally the certain lawyer should be appointed as a designated quasi-prosecutor to proceed the procedure.
小沢の件もちょっと触れておきましょう。
Regarding the Ozawa case,
この問題については小沢氏が起訴されて無罪になったということから政治家の中にこの検察審査会制度をやめるべきだという意見があります。
So, because the Ozawa has been prosecuted under this new system of the binding prosecution investigation commission's decision, so some politicians now start arguing that this new system should be abandoned.
私はその起訴された事件が常に有罪であるべきだという我々の観念があるので、無罪になった結果に対して制度論に及んでいるということ自身にはちょっと問題があるというふうに思います。
So in my understanding, even though Mr. Ozawa is acquittal finally, still this system should be justified because even though it is prosecuted under such a binding decision by the commissions, all cases would not be so much becoming guilty.
Yeah. So what he said is that we should not take it granted that all prosecution should be, convictions. So.
小沢のケースで改善の余地があるとすると、検察審査会の委員は調書を見て起訴不起訴を決めてるんですね。この調書だけを見て決めてるというところに一つの限界があるかもわからないので、 この検察審査官システムの中にもう少し、なんて言いますかね、その大陪審のような直接尋問ができたり、そういう手続きも入れる必要があるんじゃないかなと個人的には思っています。
So in my opinion, maybe the current system has some limitation because currently the member of this Prosecution Investigation Commission can review only the statement as evidence to decide their decision. They have no right to have their testimony directly by the such commission members. Therefore, you can. No. They are just reviewing only documents, the statements.
Yeah, rather than just statements, but it's also documents. But they would look at documentary evidence too.
No. Just a statement. Statement, not a statement. A statement in the writing. So the written statement. Yes, only written statement of the accused. Therefore, they have no right to make any the testimony directly, like the grand jury. That is a little bit limitation on the current the capacity of this commission to decide exactly who should be exactly prosecuted.
Yeah, I myself is a little ambivalent about this system because I think there is a serious implication of double jeopardy. So my proposal has been to limit this procedure to those defendants who are in power, like politicians and government employees and so on. And also, I have been arguing that even they should be guaranteed protection of fundamental human rights in criminal procedure. So I think this system needs much more improvement. But on the other hand, as Shinomiya-san and Marishima-san said, basic idea to give binding force to this commission is on the basis of increasing democratic basis rather than reforming criminal justice per se. Okay. But anyway, she has been extremely patient to wait.
Hi, my name is Yachio Isako. I work at Market Hatfield School of Government, Portland State University, Oregon. I might be the only one in the room that doesn't have legal background, but I've gotten master in public administration, and specifically I studied on public participation, civic engagement, compared Japanese systems and American systems. But you have touched on the expansion of the public participation and the judicial system especially, and then you talked about the power of people. And I'm just curious to know what your take on this participation of the general public in the judicial system could lead in the other civic participation or public participation in other public issues or for public well-being, especially the central government is trying to decentralize their power into local government.
Okay, that's a good question. And University of Washington, he actually changed. His name is John Gastelio. He used to teach in the Department of Communication. He's a Californian. He was actually a very effective political campaign organizer, but he got PhD in communication. He used to teach at University of Washington. And he actually started something that being taken up by the, I think, state of Washington as well as Oregon. When there is something called the citizens referendum system. When there is people's proposal to introduce any kind of system or legal measure in the form of using the ballot system, he created a system that, like for example, try to think about the introduction of, say, three strikes law in the state of California, which already passed, but nonetheless. Then state of Oregon, as well as Washington, the group of citizens will be actually recruited to discuss the pros and cons of the introduced bill. And they will deliberate over a couple of days. And they are forced into taking positions. And they will come up with the pros and cons from the particular perspective. In the ballot initiative, that decisions are part of the information being provided to the citizens. So people can understand from their point of view what is good, what is bad from their point of view, instead of having three strikes law. It had very limited information about it, and as a result, in the state of California, it passed 1994. That really mushroomed the prison population here. And we spend more on prison and correction than education. That's one of the reasons we're being cut back. And UC system, the students are being paid, forced to pay a tremendous amount of money. So again, that initiative process actually started in Washington and Oregon because of John Castille's work. He actually moved. But if you look at lay participation system and the true foundation of democracy, you really have to go back to the Athens. That's when they had not only democracy, but they also had a direct participatory democracy. It's called a demokratia. Demo means people. Kratia is power. The power is vested upon the people. And what they meant was that the first jury system was actually congregated, or the people randomly selected from the Athenian citizens. And that system being applied to the executive branch as well as the legislative branch. The executive branch is called the Bowl, or 500. They were also selected random from the people. They serve for a year, but they have to be over 30 years of age. And they only can serve once in their lifetime. Same as the assembly, that's ecclesia, 6,000. Those 6,000 people randomly selected to serve for a year, and they served. So if you look at how the direct democracy actually operated, it's a jury system we observe here being applied to the political systems. Just imagine yourself, even here in San Francisco, the city council composed of people who are randomly selected from the people who live here. And you can actually imagine the kinds of agendas being discussed and deliberated in the assembly. But that system that was not being applied here because of the twisted and misinformed the notion of direct democracy actually originated in Athens. And, but we call it representative democracy, but that's not the democracy. They actually rejected it, representative democracy, but they actually use the direct democracy. So that's the model of the true democracy. And how much we actually want that democracy to be applied in our society, that depends on you. You really have to make decisions. You want to see whether that system needs to be applied, then you have to do something about it. I think that's a true form of democracy. And if we have even California Assembly, the Senate, use that system, I'm sure we have a free tuition, UC. We used to have a tuition-free UC system until 1967. Tuition was free. Thanks to Reagan, he started to impose tuition. Community college was free until 1968. Jerry Brown imposed tuition at the community college. So if we have that system and the decision-making bodies based on the same democratic system, you will have a tremendously different ways of government or civic society.
Great.
Hiroshi, I found this absolutely fascinating and pretty mind-boggling as a former American criminal defense lawyer. I had a couple of very specific questions. First, how long is it from detention to indictment on average? Second, since there's no pre-indictment bail, what's the percentage of people who are eventually indicted? And if they are not, is there a decision at which point they get released? And third, Peter and I were just wondering why the lay participants are only there to say that the indictment should exist and not that the indictment should not go forward.
Detention to indictment. Well, under the current Japanese system, you have 3 days detention period. And then for the one felony, I think you have extended 20 days, right? And there's about 23 days. 10 and 20 days. So 20 is 23 days.
Prosecutors may detain the suspect for 48 hours. Then, police may detain the suspect for 48 hours without judicial authorization. Then the prosecutor may detain for another 24 hours without judicial authorization. Then the prosecutor applies for judicial authorization for detention for 10 days initially. Then that 10 days may be extended for another 10 days in most crimes. And this 23-day period can be counted for each charge, so that if you have more than one charge, that period can be doubled, tripled, and so on. So, okay, this is one question. And then
What's the second question?
Yeah.
How many people are being indicted?
Proportion. Probably Shinomiya-san knows.
Yeah, I think Shinomiya-san knows more.
I'm not sure.
But you wrote a paper in a book.
New system? Yes. Oh, yeah. I mean, how many suspects are indicted under this new system? And so far, 9 was, in 9 cases, the commission recommend to indict, and and 6 out of 9 was actually indicted by the special prosecutor who was appointed by the court, and 2 out of 6 was found not guilty, and another 4 cases was still suspended.
じゃあ3つ目の質問はなぜその起訴する方向だけで起訴しない方向ではないのかという。
Well, this was established. May I, Fukurai-san? May I? This was established in 1948, as Fukurai-san said. At that time, Japan was occupied by the American military government. I'm not sure, but so they recommend Japanese government to democratize the prosecution system, and recommended to introduce grand jury system and district, just like your district attorney, be elected from the public. And as you can imagine easily, Japanese government strongly opposed these 2 suggestions. And this was the so-called sort of a compromise of these struggles.
Okay.
I have the inside report on that I heard directly from the author, because I had the fortunate chance to meet Thomas Blakemore. And he told me about this, and his comment was that so Thomas Blakemore was working for Oppler in the office of the GHQ office of the government and the courts that was implementing the new constitution, and Blakemore was in charge of criminal procedure in this. And Oppler was had been a German jurist, so he understood the civil law system. Blakemore had studied in Japan, and he understood, but he had a very heavy push from the U.S. Shall I say, cowboys in the team that really wanted an all-American, or actually an Illinois style, not cowboys, systems. And one was the grand jury. So they brought it to Japan, and Japan said, we don't want the grand jury. And he was caught right in between, and he told me that he invented this out of whole cloth. He just was in between these 2 scenarios and needed something, so he just came up with this idea out of his own imagination, and that became the Prosecutorial Reform Commission of Japan that now operates in a binding manner.
Okay. Then the final question. Okay.
I have a question too.
Oh, okay. then you will be the final questioner.
So it seems that with the Supreme Court reviewing the lay judge system this year, it's the best chance that we have for a long time to actually get the lay judge system to move to civil cases and administrative actions. My question is, has there been any evidence that the Supreme Court is reaching out to outside interest groups, such as the Japan Federation of Bar Association or non-legal persons, sort of like the Reform Council did back in 1999?
I was in Japan until 3 weeks ago, and 4 weeks ago, 3 weeks ago, it doesn't matter. And I was trying to find any information about the review process. I called some of the people that I knew, press people, because they usually get information firsthand. But they didn't know how the process is actually going. And I couldn't find any information about the review process. Shinomiya-san, do you know the review process? How it's a review? Okay, I forgot to ask you then. You can answer the process.
Are you already working?
After the questions.
Okay, okay.
So,
Okay.
Okay, I need to interview you.
So, who will answer the question?
Hiroshi goes first.
And then?
Shinomiya-san.
Yeah, another.
She has a question. Go ahead.
Oh, yeah. Okay, okay. Yeah, yeah.
Shinomiya-san will answer. Yeah. Okay, later? Okay. Go ahead.
Yeah, you ask your question first.
Okay. So I'm just curious, just hearing how Chinese lay, adjudication committee or lay quasi person must be college educated.
Yeah.
Do you have any statistics on like the educational level of Japanese, lay judges?
Well, there are all kinds of qualifications. With respect to the qualification in education, you really have to have the mandatory education completed. And I would say 99.9% of Japanese people completed the mandatory education. There are people who refuse to go to school. Thereby, there are some procedures truly that are being applied. There are people who failed to complete the compulsory education. But nonetheless, there's a system to make sure that the administrative ways to make sure that they actually have at least the record, they finished the compulsory education. So education-wise, I would say nearly everyone in Japan, in terms of education requirement being applied. In the case of China, educational requirement was not imposed until 2010. And so it was a new requirement. And that eliminated about 95% of the Chinese candidates. And there was a wonderful article came out 2010, written by the Professor Wan of one of the national universities in the International Journal of Law, Crime and Justice, which I acted as a special guest editor. So you can actually look at specific requirements being imposed on lay assessor system in China. So I can send you the article if you're really interested.
So you think almost all lay judges in Japan, well, I know that they finished up to 9th grade, technically, but after that, do you have any statistics?
One thing I want to mention that in old days, compulsory education was much less. So people who are about 75 or 80 or so did not really complete 9th education. Like my father, he had to have the high school diploma for the kind of job that he was, position that he was applying for. So he had only 6th grade education. That's because he actually grew up during the war. So he had to go to a special school to get the certificate of high school graduate. So technically speaking, there are people who did not complete 9th grade education, but they're still part of the lay participants.
But you wanted to know the educational background in terms of high school, college, graduate school, that kind of thing. Yeah. We don't have that statistics.
We do. Don't we have the?
Have you published?
Is it published by the Supreme Court?
Okay,
maybe not.
I don't think the Supreme Court has published such detailed information about lay judges.
By looking at the housewife and the house husbands, that gives you certain information about their participation in the system. So it gives you some class indications. Class usually reflect correlate with the income and educational backgrounds. The fact that that's occupations, but occupation will give you the kinds of educational backgrounds you have. So I would say the large proportion of people actually participated from group of individuals. I would say much more diversities in terms of education.
But there are highly educated housewives and housemen. For instance, my wife has a PhD. But anyway, okay. So Shinomiya-san should tell us a little about the current situation of the review commission under the Supreme Court.
Thank you, Miyazawa-sensei. I'm very happy to hear that Fukurai-san said that this introduction of lay participation took a right step to right direction. Since I'm an active member of that group to do the research jury system, and when I start to work for the Saiban-in system, it's a mixed tribunal. Some of the members of that group criticized me that you betrayed. But I'm still a strong champion of true American-style jury system because it's not it's American system, but it has two great critical points to enhance the criminal justice system fairly, or to make our society more democratized. One is to pick up the jurors or Saiban-ins randomly from the voters' roll, which means reflects the people popular sovereignty. And the second point is to serve for only only one case, and serve only one case, which means trial should be conducted to be understandable to people who have no experience of trial. That 2 points is crucial. And this Saiban system has these points. I was very much surprised observing that debate in the JRC. They discussed about these 2 points. There was no debate on these crucial points. And I was observing that debate through the camera with the media representatives. And they said, oh, so that was the time when we get this system as a good one. So, I agree, Fukurai-san, with not only the success, but the problems of this system. But I'd like to add some successes more. It is, as Fukurai-san said, the government or JRC consciously changed the criminal justice system. For example, public defender system for the detained people, and also a sort of disclosure of evidence procedure and the pretrial procedure, which is not a full disclosure, but in certain extent, it's the first system in Japanese criminal system history. And also there's been unconscious change in the criminal justice system. For example, the videotape the interrogation of police and prosecution. JRC has written nothing about this. But since the lay people is coming to the court, they have to show we did the right thing. So without any change of law, they have to begin the videotaping the interrogation. And another thing is, for example, the bail. Some judges are writing an article, we should enhance bail because the pretrial procedure needs the consultation with his or her attorney. So he or she should be bailed or something. This is also the change which was produced without a change of law. And without a change of code of evidence, the court is very reluctant to introduce the dossier as evidence to the Saiban-in court because they cannot read it, those kind of thick dossier. So many judges very much reluctant to admit those kind of written evidence. And then they urge the prosecutors, why don't you call witness? And another thing is the appeal. As Miyazawa Sensei reported to me this morning, yesterday, in Japan Standard Time, yesterday, Supreme Court decided another decision to support the Saiban-in trial, in which case, Saiban-in trial acquitted the defendant. In that case, the court suppressed the prior record, criminal record, and he was found not guilty. But the Court of Appeal, High Court judges overturned the conviction, overturned the acquittal, saying this could be introduced as evidence. And again, Supreme Court re-overturned that decision, and that court was presided by the Takezaki Chief Justice. So that is representing how they strongly support this system effectively.
Yes, in that particular case, High Court rejected trial court decision to acquit the defendant. Then the Supreme... あれは何の事件だったの
Arson.
Arson, yeah, 放火. Yeah, arson case. So, and prosecutor used the prior history to prove, as evidence. But trial court rejected, and High Court accepted it. And the Supreme Court overturned the High Court decision and remanded the case to the High Court. Okay. それで今ね、その再検討のプロセスはどうなってるか、それが質問だったんですけど。
Yeah, this is my. I'd like to give some comments, but okay, I skip it. Okay, about the review committee, the Saiban-in Act stipulates that the government should review this Saiban-in system after 3 years practice, and the committee was established in 2011, I believe, and I was appointed as a member of that committee. And so far, they are discussing about the points, which points should be reviewed. For example, eligibility of cases, or how the Saiban should be selected, or how the court proceeding is going on. Is it enough understandable for the lay people, or how the appeal court should be? That court, Supreme Court has handed down the several decisions, and about the duty of confidentiality of the Saiban-ins. And we discussed once a month, and middle of this month, we would conclude a rough discussion. And the presiding member of that committee would present us a sort of list of points should be discussed. And my expectation is, since the next year, May of next year would be the end of 4th anniversary of this system. So I think this committee would reach an agreement, or I'm not sure whether unanimous or not, but by the end of April or May or something, they could reach the sort of recommendation. And the point would be eligibility of the case, or confidentiality, duty of confidentiality, or so and so.
Do you foresee any major changes?
No.
Okay, good.
Because the Supreme Court and Minister of Justice are not. It's my personal opinion, but they are not intended to change, make a big change.
I see. Okay. Yeah, thank you very much for your endurance and strong interest in this whole event.